Good morning, all. My name is Wayne Hiller van Rensburg. I'm the Executive Officer of the Institute of Retirement Funds Africa. We would like to welcome you to our webinar this morning and would like to also thank the Office of the Pension Funds Adjudicator for joining us this morning. Before I introduce the speaker, I just wanted to touch on the topic quickly. Obviously, you're going to work through it. Two very important topics for every practitioner in the retirement sector in South Africa around 13A contraventions, and Tshepo Dooka from the Office of the Pension Funds Adjudicator will take us through that and what it is that the office has done to assist members. I think one of the important things to remember here is that the Financial Sector Conduct Authority has made it clear that they can't take action against employers in the current legal environment. However, the Office of the Pension Funds Adjudicator has stepped in to provide some relief to members. And I think just from a personal perspective, this is a positive development in providing the solutions that members need on a free, cheap, accessible basis. And the second section, or the second portion that Tshepo will cover, deals with the methods in which death benefits are paid. Both very important issues and very relevant to every practitioner, like I said. So without further ado, I'm going to introduce our speaker this morning. I'll use all her names. So good morning, Tshepo Moira Dooka. Tshepo is an admitted advocate of the High Court of South Africa since January 2000. She obtained a B.Proc degree from the University of the North, an LLB degree from University of the North, as well as an LLM from University of Pretoria. She also has obtained certificates in advanced corporate law and securities law, certificate in arbitration, certificate in advanced labor law, certificate in legislative drafting, and she's also completed a manager's program at the Wits Business School. Just from her academic experience, you can see that this is someone with a deep knowledge in the pension sector. Then Tshepo's current role, she's the Senior Assistant Adjudicator, a team leader at the Office of the Pension Funds Adjudicator. She's been with the OPFA since October 2008, so she has lots of experience there. She is heading up a team in case management and responsible for investigation and drafting. Prior to joining the Office of the Pension Funds Adjudicator, Tshepo had several positions in academia, again, sort of just reaffirming her deep knowledge of the pensions law sector. Tshepo, thank you and welcome. And the IRFA thanks you for making the time and taking us through these issues and all our stakeholders. Over to you, Tshepo.
Thank you very much, Wayne, and thank you for the invite and allowing the Office of the Pension Funds Adjudicator to give a case law update. And good morning, colleagues. What I'm going to be focusing on today is the issue that we deal with on a day-to-day basis. The majority of the complaints that we deal with involves Section 13A non-compliance, meaning employers who don't pay the contributions to the fund on behalf of their members. First thing first, I'd like to discuss the case of Van Wyk, J.R. Van Wyk versus the Metal Industries Provident Fund. This case confirmed the employer's failure to pay all contributions on behalf of the complainant. The fact of the case is that the complainant was employed from January 2012 to date that the determination was issued. He is a registered member of the fund. But then what happened is that the employer last paid contributions on behalf of the complainant in September 2018, but then the employer continued to deduct same from his salary. This is what led to the complaint before us, where the complainant was not happy with what the employer did. And the fund in its response indicated that the contributions were received on behalf of the complainant for January 2012 to June 2018 and September 2018 only. And they gave us the period of outstanding contributions as July 2018 to August 2018 and October 2018 to date, because the person is still employed. And these are some of, not only some, this is what happens on a day-to-day basis when dealing with complaints relating to Section 13A non-compliance. The fund in its response gave us the total amount of contributions that the employer owes. They gave a breakdown of the amount that the employee's portion and the employer's portion. So the total amount of outstanding contributions was 192,305.13 cents. This covers the period that the employer did not pay contributions on behalf of the complainant. And also what the fund said is that they notified the director of the employer and all parties concerned regarding the outstanding contributions by sending out letters, 30 days, 60 days, and 90 days letters, notifying the director of the unpaid contributions. But that is all that the fund did. The fund did not report the employer to the FSCA or even to the NPA for non-compliance with Section 13A. What the fund said was that the employer signed an acknowledgement of debt with the fund's attorneys, which has not worked out because the employer did not adhere to the AOD signed. And the fund indicated that the employees were not notified of the funds, the employer's non-compliance, which is one of the duties that the fund needs to make sure that they do. In the adjudicator's determination, the adjudicator held that it is just not enough to say that non-compliance letters were sent to the employer. The fund has a duty actually to take further steps, which includes notifying the employees of the employer regarding the non-compliance and take legal action against such employer. It should be noted that the employer's failure to pay contributions not only affects the fund credit, but it also affects risk premiums as well, which means that in the event of any death or disability, it means the complainant or the member will not be covered. So that is something that needs to be taken in a serious light, because it does not only affect what the complainant will take home when he or she resigns. In the High Court of a Joint Municipal Pension Fund and Ihlanzeni District Municipality, the High Court referred to Section 7D of the Act, which refers that one of the duties of the board is to take reasonable steps to ensure that contributions are paid timeously to the fund. The court held that the right to institute legal proceedings against an employer to pay arrear contributions fell squarely into the concept of such reasonable steps, and a fund has thus the statutory duty to institute such action. This is something that we have noticed that the funds do not do. They will only mention that they've notified the employer with the 30 days, 60 days, and 90 days letters of non-compliance with Section 13A. But in some instances, they will indicate the funds in the responses to various complaints. They will indicate that they've referred the employer's conduct to the funds attorneys to take legal proceedings. But that's as far as that. We don't even get to know or be provided with feedback of such proceedings. So in light of the above, the adjudicator ordered the employer to pay the total outstanding contributions of 192,000 for the period of outstanding contributions. But then when we requested, because now in order to assist members to enforce our rulings, we have requested funds to provide us with the amount of the contributions owing so that we can issue orders sounding in money. So what the fund did, they provided, yes, the amount of 192,000 as the amount owing, but then they did not include the period from April 2022 onwards, as this person is still employed. So what we did in the order, the adjudicator ordered the employer to pay the amount as provided, and also order the employer to provide the contribution schedules for the period April 2022 to onwards, so that the fund can calculate and provide the employer with the amount for that period. I just want to hand over to Naheem to also explain how the new approach that the office is taking with regard to order sounding in money, specifically relating to the late payment interest that is charged on the amount outstanding. In some of the cases that we deal with, we've noticed that the late payment interest is way above the amount owing. So in that regard, the duplam rule kicks in, and this is the approach that the office is now taking to ensure that the late payment interest does not exceed the capital amount owing. I'll hand over to Naheem, then I'll come back to continue with the discussion of other cases.
Thank you, Tshepo. So I'm sorry I don't have slides for you. This was just a late request by the adjudicator to discuss this this issue of duplam. So you may have seen recently that the orders that are coming out of the adjudicator's office include a calculation of the amount that is payable in terms of late payment interest. What we have done is we have implemented the duplam rule when calculating those amounts. The duplam rule is, as you know, it's part of our common law. It's been part of our common law for a very long time. And it regulates how much interest can be charged on a debt. So just to read a quotation from one of the judgments, which was the Standard Bank of South Africa versus 1&8 Investments, where it explains what the duplam rule is. And it says, it provides that interest stops running when the unpaid interest equals the outstanding capital. When due to payment interest drops below the outstanding capital, interest again begins to run until it once again equals that amount. And it was also more recently in the Slipknot Investments judgment endorsed by the Constitutional Court as forming part of our common law. And as you know, the late payment interest, currently it's prescribed in terms of the Government Gazette Notice GN 397 in Government Gazette 33182 of 12 May 2010. And as we know, there's going to be the new conduct standard that is coming into effect early next year. And then that will regulate the interest, late payment interest that is payable. But in both of those documents, the application of the in duplam rule has not been excluded. So when you're calculating your late payment interest, please be sure to apply the in duplam rule. Thank you.
Naheem and Tshepo, sorry, just to ask you there, when talking about the in duplam rule, and I know there are many lawyers online, maybe just a practical example for people who don't necessarily understand it. I know you mentioned it, but maybe just you can maybe just use a rands and figures, example, if possible. Yeah.
Tshepo, you want to do it, or should I give it a step?
How I can explain the in duplam, I'll give an example. If the employer owes 80,000 as the amount for the outstanding contributions for a particular period, what it means is that the minute the late payment interest reaches that 80,000, it will stop there. It will not exceed the amount or the capital amount owed by the employer. I don't know if that makes sense to you.
It does. So it basically says it can never be more than the original debt. That's
Yes.
Okay. Thank you.
Yes, just to add to that, Wayne, also, if there's been a partial payment and then that reduces the interest, then interest will continue to run again until it reaches the capital amount again. So,
okay.
Yeah.
Thank you,
Tshepo.
Okay, thank you so much, Naheem. I'll proceed to the next case, still on Section 13A non-compliance, which has the effect on risk benefit. As you could recall, I've mentioned in the previous case that the non-payment of contributions on behalf of the members does not only affect the fund credit, but also their risk covers. I'm going to discuss the case of Kava and another versus Metal Industries Provident Fund. This case, it confirmed the fund's failure to monitor and ensure that the employer pays all contributions on behalf of its employee. The complaint initially, the deceased is the one who lodged the complaint while he was still alive. And what happened in this case is that the deceased was a member of the fund until the 3rd of June 2021. Prior to his death, he applied for a disability benefit, which was repudiated due to non-payment of contributions. Then he lodged the complaint with the adjudicator on the 20th of June. Sadly, he passed away on the 23rd of June 2021. That was even before the funds could respond to his complaint. And what happened was that the complainants, as the deceased's major children, submitted another complaint on payment of a death benefit. Remember, the fund repudiated the disability benefit claim based on the fact that contributions were not up to date. In lodging the complaints for a death benefit claim, the complainants submitted that Provident Fund contributions were deducted from the deceased salary and the employer failed to remit same to the fund. They submitted that the deceased attempted to claim his disability benefit, which was repudiated because of outstanding contributions. In submitting their a complaint for this death benefit, the complainants learned that the employer had not paid contributions to the fund, and accordingly, no death benefit could be paid as well also. They've noticed that the fund credit was also less as not all contributions were paid. The fund, in its response, provided the period that the employer paid contributions on behalf of the deceased, and it was up to November 2017. The fund also indicated that the deceased applied to receive an income from the Permanent Disability Scheme on 8 June 2021, and the claim was assessed and rejected in the same month due to arrear contributions. The fund also indicated that the contributions that needs to cover the cost of death benefits are in arrears, therefore no insured benefit is due to the deceased or his beneficiaries. And as a result, the circumstances does not allow the fund to pay the beneficiaries the death benefit. It will only pay the fund credit to the beneficiaries. Again, the fund indicated that the director of the employer was notified through the letters, as previously mentioned, of the unpaid contributions, but that goes as far as that. In the determination, the adjudicator referred to the rules 8.1 and 8.2 dealing with contributions, and the employer owes contributions for the period that is been mentioned in the slides there, which means that the employer is in contravention of Section 13A of the Act and Rule 8 of the fund. The fact that contributions were last paid in November shows that the fund failed to comply with Section 13A, that is to monitor and ensure that the employer complies with the payment of contributions. It also does not appear that the fund reported the employer for non-compliance with the provisions of Section 13A to the FSCA. Due to the fact that not all contributions were paid by the employer, the deceased fund credit and the insured portion were affected. In the case of Matekane versus South African Municipal Workers Union, National Provident Fund and others, the adjudicator held that the employer was legally responsible for the beneficiaries not receiving the risk portion of the death benefit in the event where the employer is responsible for the repudiation of the risk benefit, repudiation of the payment of the risk benefit, as it is happening in this case. The fund provided the adjudicator with the calculation of the death benefit that the employer is liable for had all contributions been paid, which means that now the employer is held responsible for the repudiation of the risk benefit, and the adjudicator ordered the employer to pay, firstly, the arrear contributions for the period that contributions were not paid for the deceased, plus the risk cover amount that the fund provided. The employer had to pay that to the fund in order for the fund to pay the death benefit to the beneficiaries. So what I'd like to emphasize in that case is that sometimes when the fund does not take responsibilities or ensure that they monitor and report non-compliance with Section 13A, it has the effect that it had in this matter. The member applied for a disability benefit, which was repudiated for arrear contributions, and sadly that person passed away, the beneficiaries applied for the death benefit, which was also repudiated based on the fact that not all contributions were paid. So if funds can take the responsibility of ensuring that contributions are paid on time and report the non-compliant employers, we could avoid situations the same as the one that happened in the cover matter. On that note, it's upon the fund and it's upon us as the office to ensure that we assist members and beneficiaries as much as we can to make sure that they get the benefit that they deserve. I don't know if there are questions at this stage or if I can proceed to discuss the next case.
Tshepo, maybe before you move on, I think that the next case you were going to talk about the payment of death benefits.
The mode of payment, yes.
The mode, yes, sorry, the mode. That's correct.
Yes.
Just a couple of things. Maybe I see we haven't got any other questions. We had one question, and Naheem assisted with that. That I was thinking of in the first matter. You refer to the case where the High Court said that it was the duty of, it fell within the duty of trustees to institute legal action should there be a failure by the employer to make the contribution payments. What you doing, and I'm just trying to, I think what I'm trying to, no, I think what I'm trying to ask here is that your office obviously hasn't dealt with and wouldn't deal with the responsibility of the trustees. But I mean, this is something that if a trend is picked up, I would assume you would have to, or would share this information with other regulators that do manage or regulate the trustees, the FSCA, and in this example, you know, if there were many instances where you'd pick this up.
Wayne, what I can also mention is that we do get complaints lodged by the funds against employers, especially where the fund has picked up that the employer has been non-compliant. We do get complaints lodged by the fund against the employer, and that is one of the action that the fund can take against those non-compliant employers.
That makes a lot of sense. So instead of going to the High Court, the fund could then also lodge a complaint with your office.
Yes.
Okay. Thank you. I know that's valuable. I think there are some other questions. If I can just have a look. Okay, this is a question related to, so we can find the answer. The other questions are just a question about regulated publishing. Then, you know, before we move on to the next topic, and I know you focused on these two issues. Is your office seeing an increase? Has there been any change in the number of complaints around 13A in the last while? I mean, I'm talking maybe COVID, post-COVID, anything like that you've picked up?
Yes, we've received a lot of complaints on non-compliant with Section 13A. And also the way the pattern that we've noticed is that some of the employers were given relief due to COVID-19 from paying contributions, but then the fund, it doesn't look like the funds communicated with members to indicate that the reason why for a particular period this is the situation is because the employers have been granted relief from paying full contributions. So we still get complaints where members will be querying why only a risk cover was paid for a particular period, and that's when the fund receives the complaint, that's when they start saying for that period this is the position. Sometimes there is in the response itself, it's not clear until we go back and probe to say, kindly indicate if this particular employer was granted a relief from paying full contributions due to COVID.
Thank you. Yes, that's definitely helpful. I see Naheem is assisting with some of the answers here. Let's just see if there are any others. There was one issue raised here, and I think let me not preempt anything. Does the non-compliance process apply if the employer was not paying for one member?
Yes, if non-compliance doesn't mean it has to be for so many people. If you've got a particular member that the employer did not pay contributions for and it comes before us as a complaint, we will deal with it.
Thank you.
Unless if there are reasons, maybe the employer can provide to say this is because of 1, 2, 3. But yeah.
Yes, so I mean, obviously for legitimate reasons, for whatever, but I mean, non-compliance, like you were saying, is non-compliance. Then I don't know if I'll ask the question and how does the OPFA handle the topic in the context of self-administered funds? Yes, okay, so I think it's just, I mean, are self-administered funds treated any differently? I think that's probably the question that's being asked here. Yeah.
No, we don't treat them differently. We apply the act and the rules of the fund, and yeah.
Thank you. I just want to see if there are any other questions here. These have all been very helpful. We've got someone who'd like to ask a question live, so I'm just going to allow them. Someone called Richard. So I'm going to just give you an opportunity to talk, Richard. If you want to switch on your microphone, you can ask your question. Okay, maybe Richard doesn't want to ask the question anymore. I've got another question. I'm just going to ask Marilyn, if you want to go ahead and ask your question.
Sorry, that was an accident. I'm lowering my hand. Sorry.
No problem. All right, I think. Sorry, I'm just having a quick look. We've now got a whole lot of questions coming up. I don't know if you can see them. Shall I just read them for you, and then Tshepo, between you and Naheem, and so, yep. What is the approach PFA in cases? What is the approach of the PFA in cases where the employer has been liquidated and the fund submitted a claim, but the claim was not paid? Will the PFA consider a complaint against the 13A responsible person personally?
And Naheem can assist in that regard.
Yes. So we would normally, if a participating employer has been liquidated, it would be an out of jurisdiction matter because we wouldn't be able to deal with it. And then I think the question is, will the PFA consider a complaint against the 13A responsible person personally? Yeah, we will consider it, but I don't think we've dealt with one as yet. Have we, Tshepo? Have you come across anything like that?
No, I haven't.
Yeah, I think we will consider it, but yeah, I can't give you the answer of what our outcome would be right now, but
yes.
But yeah, we would consider it. Thanks.
Thank you. And I mean, like you said, we're probably very specific on the facts of the matter to see whether liability can be, placed on that person. And then the other question, which I think is also a very interesting question, is should trustees not be held liable in addition to the employer? And I'll just ask the question, and then I'll hand over to you to share your thoughts.
Well, to me, the Act refers to the employer paying contributions. If the employer does not, then it's the employer that must be held liable for that. That's my thought. And I don't know if to what extent can we say the board, the trustees must be responsible for non-payment of contributions by the board, but they can be responsible for not ensuring that the employer pays contributions on time.
So I mean, that's more a governance failure, which I think is dealt with
Yes.
with other forms of sanctions rather than this. Thank you. I think that's it. Let's move on to your next section. Thank you, Tshepo.
Okay, thank you very much. The next topic that I'm going to discuss is more on the mode of payment of a death benefit. In this matter of Moremi, the board allocated the benefit, paid the benefit allocated to the minor children into a beneficiary fund. The complainant is the mother of the minor children, and the total death benefit amounted to 610,896. So now, when allocating the benefit, 35% was allocated to the life partner, 11.31 allocated to Louisa, aged 17, 25.43% allocated to Patricia, aged 7, and 28.26% allocated to Pretty, aged 5. Now, the complainant was actually not happy with the decision of the board not to allocate her a benefit. But then that's not the focus for today's presentation. She was also aggrieved by the decision of the board to pay the portion of the benefit allocated to her children into a beneficiary fund without her consent. The fund submitted, amongst others, that the complainant was no longer in the deceased life at the time of death, hence maybe the exclusion from being allocated. And also they were not, the deceased shared the same household with another person. And in providing the reasons for paying the benefits of the minor children to the beneficiary fund, the fund advanced the following reasons: that the deceased provided financial support for the children on a monthly basis, and it is reversing that financial burden caused by the deceased death by ensuring that the children's benefit will be paid monthly until they attain the age of majority or become self-supporting. The fund continues to pay 1,250 per month. If it continues to pay that, the benefit will provide for the minor children until they attain the age of majority. Those were the reasons for paying the benefit into a beneficiary fund. The fund stated that it is financially viable for the children for it to pay installments, as the benefit will cover their needs until they receive, and they will receive financial assistance for the expenses relating to their maintenance. So the fund gave the balance as appears on the slide. So say Moremi had 74,000 and OP Moremi 155, VP Malimela 192. The fund submitted that the complainant confirmed that she is unemployed, sometimes helps people with their laundry, cleaning, etc. to make a living. The fund indicated it will be in the children's best interest to receive their benefits in installment. but then the complainant can apply for advances for school fees, clothing, etc. I'm not going to dwell much on what the fund considered the complainant as for purposes of not being allocated a death benefit, because the focus for this is more on the mode of payment of the death benefit. Now, in the determination, the adjudicator indicated that one of the duties imposed by Section 37C is that the board must determine appropriate mode of payment to each of the beneficiaries. And paying a benefit for the minor child to a guardian should occur in the normal course of events unless there are cogent reasons for depriving the guardian of the duty to administer the financial affairs of his or her minor child. And in this case, it does not appear that the fund had cogent reasons for not paying the benefit to the minor child. Referring to the Ramanyelo case, the adjudicator reiterated that the board must follow the following factors in determining whether to pay a benefit to the guardian or to a beneficiary fund. Number one is the amount of the benefit. Secondly, the ability of the guardian to administer the money, the qualification or lack thereof of the guardian to administer the money, and that the benefit should be utilized in such a manner that it can provide for the minor until attains majority. In this matter, it does not appear that the board assessed the complainant's ability to administer the benefit on behalf of the minor children. The board did not even provide the reasons for paying the benefit into a beneficiary fund, other than mentioning that the complainant is unemployed. And as the adjudicator indicated, the complainant's unemployment status does not automatically mean that she cannot administer the funds if same was paid to her. So in this regard, it appears that the board used or applied a blanket approach in paying the minor children's benefit to the beneficiary fund due to the fact that the guardian is unemployed, which cannot be justified and goes against the factors set out in the Ramanyelo matter. The discretion of the board to pay the minor children's benefit into a beneficiary fund without conducting a thorough investigation on the complainant's ability to manage the financial affairs amounts to improper exercise of power and maladministration of the fund by the board. In this case, the board failed to exercise care and diligence in the mode of payment of the death benefit. Therefore, the decision of the fund to pay the minor children's portion into a beneficiary fund is assailable on the evidence submitted, and the adjudicator finds it appropriate to set it aside. I must mention that in some of the matters that we deal with relating to, especially where a mode of payment is one of the issues raised in the complaint, when the fund files the response, they don't always indicate the steps they took to reach a conclusion that the benefit must be paid to the beneficiary fund. It is only when we start probing further on what is it that led to the board to decide to pay the benefit to the beneficiary fund that we will be provided with reasons like the guardian is not employed and so on and so on. But it does not come out clear, and also the decision, the board of the funds, sometimes they just take a decision to pay the benefit of the minor children to the beneficiary fund without even the consent of the guardian, which is something that is is not provided for, especially when you look at the factors in the Ramanyelo matter and one of the, in terms of Section 37C of the Act. In some matters, the guardian where the guardian maybe lodges a complaint saying the fund has not paid the benefit for on behalf of my minor children, only to realize, no, the fund released the money, but the money has been paid to the beneficiary fund. Then that will show that the guardian was not even aware that the money of the minor children has been paid into a beneficiary fund. So that is one of the things that we deal with, and we wish that funds can get a different approach before reaching a conclusion to pay the benefit on behalf of the minor children to the beneficiary fund without the consent of the guardian. And that's conclude the end of my presentation. I'm not sure if Naheem, maybe you would like to add something to the last case that I just presented.
No, thank you, Tshepo. I think we can take any questions.
Okay. Then we can take questions, if any.
Tshepo, there are a few questions and a few hands. Maybe if we can start with the people who want to ask the questions live, and then we can look at the written questions. We've got David and we've got Richard. So we'll ask David to ask his question first. If you can unmute and then ask your question.
Thank you, Wayne. Thank you, Tshepo. I hope everybody can hear me. Tshepo, I just wanted to thank you for your explanation of that last case on the mode of payment. And I think we all agree that a proper investigation needs to be done by the fund in terms of the sort of understanding whether or not the guardian's competence and the probability of that money being used for the benefit of the minor children is high or low, and that needs to inform the decision about whether or not to use a beneficiary fund. And I think that needs to be understood by boards across the spectrum, because too often they do apply a default rule, and it creates this level of problem for the adjudicator, because you have no option but to set it aside.
Yes.
I think, you know, we need to be encouraging boards to do the investigation to make sure that the guardian has the level of competence, the probability that the money will be used for the benefit of the child is high, and there are ways that you can do that investigation. So not really a question, just a thanks for making that point.
Thank you so much, David.
Richard, if you want to ask your question. I see there are two Richards here now. All right, maybe let's continue, and we'll get back to the question. So the first question: what is the PFA's view of what a thorough investigation of a guardian's ability to manage a minor child's benefit should involve? I don't know if they are, but if there's something that your office could give general comment on.
I must say, we cannot give guidelines on what the fund must look at specifically, but there has to be we have to be comfortable that before a decision was made, there was some investigation on the guardian's ability to manage the financial affairs, or even to take care of the minor children. It will be difficult for us to pinpoint exactly what the fund must do, as like to do 1, 2, 3, 4, because if they don't do 5, 6, and we feel that 5, 6 need to be done, then it will be as if we provided guidelines on those facts. I don't know if Naheem, you want to add to that.
Yeah, Tshepo, if you can just go back to your previous slide, I think it was with the Ramaniello matter. Before that.
Must I go back again?
Yes, yes, please. I'm just, there was a slide that had certain factors that, I think maybe the one, yeah, this one.
This one.
Yes, so this is a guideline, I would say, but it's not binding. Obviously, a fund shouldn't veto its discretion. And if there's anything else that needs to be looked at, then it should look at that. Yeah.
Thank you. I think when people look at the recording again, or maybe go through the slides, Tshepo, they'll have an opportunity to study this in more detail. Yes.
And if there are questions that needs to be clarified or further questions, they can always send them to me by email, and I'll gladly respond to that.
Thank you. Then let's just see. We've got a few other questions, and I don't know if Richard wants to talk. See, Eleanor, who wrote a question, also raised her hand. So I don't know if it's a new question or it's the same question, but Eleanor, go ahead.
Hi, thank you. Thank you, Ms. Dooka. I really appreciate your perspectives here. I've just come across a slightly different their value to minor children, and that is really less about the competency of the parental guardian and more about the protections provided, particularly in the event of the parental guardian themselves passing away, leaving the child before they turn 18. And the risk that if you pay the benefit directly to the guardian, the likelihood of the guardian keeping that money separate in the name of the minor child is relatively small. And once the money is commingled, in other words, say put into the same bank account as the guardian's bank account in their name, if the guardian then passes away, the money, which is actually the asset of the child, is now commingled with that of the guardian and will fall into the guardian's deceased estate, possibly being consumed by creditors, and not being available. So if the money is in a beneficiary fund and the guardian passes away, then the monthly support continues uninterrupted for the minor child. The monthly payments will then just be paid to whoever now takes over the care of the minor child. And that seems to be a really valuable aspect of using the beneficiary fund as a mode of payment, particularly if the transferring retirement fund has put in the effort to negotiate sensible fees and to make sure that the beneficiary fund is properly governed and so on. I'd just be really interested in the adjudicator's opinion on that.
Okay, Naheem.
Okay, so in any matter dealing with the rights of a child, you have to look at what is in the best interest of the child. The legislation here would have, if it intended that minors' benefits should always be paid into a beneficiary fund, because there's a possibility that the guardian could die and there's the assets would be mixed up, then it would have provided for that. But currently the legislation requires you to decide on the mode of payment, and you have to investigate whether that mode of payment which you intend on implementing is the best mode of payment that can be implemented. So when it comes to assets being mixed up in the deceased guardian's estate, then it's something that has to be dealt with in terms of the Administration of Deceased Estates Act. A claim will have to be lodged with the executor on behalf of the minor child, and that money would then have to be ring-fenced by the executor.
Yes.
I don't think you can take a blanket approach by saying that because this there's a possibility that the guardian will die before the minor child reaches majority, then it must in all cases then be paid into a beneficiary fund. That's not what the legislation says you should do.
Yes, currently the payment mode of payment must be as per what the legislation say.
Thank you.
I think we have time for one more question maybe, and I think it relates to this whole. No, I don't think it does. So the question is, does the office have a view on what level of qualification of a guardian would be considered sufficient to indicate the ability to manage the financial affairs of a minor child?
Come again, whether the office has
a view on what kind of qualification the guardian would need to be considered appropriately qualified. Then again, the wording isn't good, but you know,
I cannot specifically say there is this specific qualification that needs to be there, but obviously there are certain conducts that will disqualify one from managing the financial affairs. If the person can manage his or her own financial affairs, for example, that could qualify, but I cannot specifically pinpoint that this is 1, 2, 3 that is needed.
Yes, I think, Tshepo, just to add to that, it's probably more important to see that this person is a responsible person. You know, you could be the most qualified person, but then you're not responsible. Your name could be Mr. Steinhoff or something like that, and you could then so I think it's one of the factors to be taken into account, but it's not a determining factor. Yeah.
Thank you. And that gives us 1 minute to thank Tshepo and Naheem for participating in the webinar, and all the people who attended for participating. It was of great value, and thank you for making the time and putting in all the effort for preparing the slides and giving us your thoughts. Tshepo, any last parting words from your side?
Nothing much except to thank everybody that has attended and all the contributions that were made and all the suggestions and some of the questions that we managed to deal with, and the ones that might still come, of course, we will deal with. I just want to thank everybody, and some of the issues raised, we will look into that and see how best we can incorporate or assist.
Thank you, Tshepo. Naheem, is there any parting words from your side? Are there? Thank you, Wayne, once again for the opportunity. I think everything else has been covered by Tshepo. Thank you.
Okay.
Thank you, everyone, for joining us. The Institute of Retirement Funds Africa again wants to thank everyone here and the Office of the Pension Funds Adjudicator. We will share the slides and the recording in the next day or two. Thank you very much, and goodbye. Thank you.
Thank you so much. Enjoy the rest of your day.
Thank you. Bye-bye.
Thank you. Bye.